Dear viewers, welcome to BW Legal World Dialogues. I'm Ashrama Ori and we are in conversation with Niharika Karanjawala, Senior Associate at Karanjawala and Company and one of the renowned lawyers in the defense team of Aryan Khan matter in the Mumbai cruise ship drugs case. A very warm welcome to the show, Niharika, and so pleased to see you.
So good to see you. Thank you for having me on.
So Niharika, cinema and controversies have always been two faces of the same coin. But this controversy or this controversial prosecution case targets a star's son, Aryan Khan, son of Mr. Shah Rukh Khan. Now that Aryan Khan has rightly received the bail, let's look at this a little more academically. This was a case of no consumption, no possession, and yet a young man is incarcerated for nearly a month. Now, why did this happen and what are your thoughts?
You know, Ashma, as you rightly pointed out, I do feel that cases which involve a celebrity figure or a figure closely linked with a celebrity that capture the media attention and the public attention, I have often found that those investigations sometimes tend to get a little skewed. There are very, very high emotions on all sides. Everyone has very strong opinions about it. The agencies also come out hitting hard as though they're making a point sometimes. And yes, as we have seen in a certain way, certainly Aryan Khan did pay the price of being Shah Rukh Khan's son. Sometimes the agencies push back even further to show that we're not going easy on someone just because they're a celebrity's child, and you see it going completely in the other direction where, like you said, in the case of no consumption, no possession, 25 days without bail, So.
Absolutely, Niharika. And, NCB has been in the light for all the right or wrong reasons. And, they've gone forward to say that they have evidence to show that Aryan Khan is a regular consumer of drugs. They've been, that there was a conscious possession. It was submitted that even though medical testing was not done to determine consumption, the instant case was one of conscious possession and planning to consume. Now, this seems a little too far-fetched. How would you describe this from a legal standpoint? What are these, elements that we're discussing? And what does it mean for the case going forward?
So, like you said, Ashma, it's an interesting conjunction of circumstances where the NCB maintained that there was long-term drug use, and in order to establish this to the court, they provided what they said were WhatsApp chats. That being said, it was not shared in open court. It was something that was shown in cover to the judge, and WhatsApp chats in any case are something that need to be proven at the stage of trial in order to be considered admissible. So we argued back that there was no question of admissibility of that evidence at this stage. And that too, so I'll deal with it separately. I'll deal with it first from the perspective of consumption, second from the perspective of the theory of conscious possession. Now, when we deal with consumption first, I do find it interesting that while they said he is a long-term consumer of drugs and there are these conversations and things like that, they also didn't conduct any medical tests to determine whether there were any drugs in his system. And when asked this by the court, the learned counsel for the NCB said that it simply wasn't their case, that this was a case of consumption on behalf of Aryan Khan, and as a result, they didn't have to get the tests conducted. Now, one or two things to say here with regards to WhatsApp conversations. First of all, WhatsApp conversations can always be taken completely out of context. Words can be twisted, especially the youth tend to speak in an off-the-cuff kind of manner that, when looked back at suspiciously, could seem suspicious, but at the time could be completely innocent and completely innocuous. Secondly, let's not forget that this is someone who has studied abroad. He studied in California. There are places abroad where the use of marijuana for recreational purposes is completely legal. Now, if you take a conversation from that time, hypothetically, I don't know what conversations were shown to the judge, so I don't want to mislead and make it seem like that. But hypothetically, if one takes a conversation from that time and tries to link it in to an incident that has allegedly taken place 3 years later, you're creating a situation that seems suspicious at the outset. And when you look into it a little bit, you find that it's not. It's all completely innocent. One conversation might be about something that is completely legal in that time and place. And by linking it up to something else, you're just putting forward an unfair narrative against an individual. Now, when we come to the question of conscious possession, and this is something that was argued in court very ably by our seniors that led us, conscious possession cannot be taken to mean that if I am friends with somebody, I must be aware at all points in time what is in that individual's pocket, and I can also be held liable for those things. That isn't what the letter and spirit of the law is at all. The intent behind the law is to ensure that habitual users and, in point of fact, habitual users and traders in narcotic substances cannot shield themselves from liability merely by getting someone else to hold on to contraband or illegal materials. That is what the intent behind this is. They had to prove in some way that Arbaz merchant was acting as Aryan Khan's agent and was acting at his behest if they wanted to make out a case for conscious possession. They simply said, look, they've been friends since they were very young, and as a result, surely he knew what Arbaz merchant had on him. So the fact is that it all leads to a situation where you're developing an awfully thin case against an individual, an awfully thin and awfully tenuous case against a person. And going forward with that trial, I would be interested to see how their investigation progresses and what, if anything, they ultimately feel they'll be able to charge Aryan Khan with when that investigation comes to an end.
Absolutely. So to press charges, they need to have more than what they really have.
Something
right
a
now.
little more concrete. Yes. And
Yeah.
especially when you're alleging a conspiracy, as they are, it has to have more substance than just, look, it can't possibly be a coincidence, so it has to be a conspiracy. There has to be more substance on that.
Absolutely. And we mentioned the WhatsApp chats, Niharika. Now, oftentimes now, especially any case that comes up, the first thing that gets leaked out is the WhatsApp chat. Now, here's a case where even the chats weren't revealed to the defense team, but they're out in the open. Now, how does this really work when we're speaking of the letter of the law very strictly?
It's one of two options. Frankly, with regards to the media always gets the scoop on any high-profile story. That is the job, right? So the media, I'm sure, has informants in various aspects of every framework of every agency. That, I'm sure, is a fact. So, I mean, there are ways for the media to get this information. Secondly, it is always possible that what comes forward in the media is not actually accurate. So it might be in the newspapers that these are the WhatsApp chats on Aryan Khan's phone, but those may not necessarily actually be the conversations on Aryan Khan's phone. So if the agency decides to put forward a case against him, until they produce some of those chats in court and try to prove their admissibility, I would be hesitant to actually believe that anything is legitimate if I just saw it in the newspapers, say.
So also taking this forward from the prosecution agency's point of view, aren't they supposed to be safeguarding these elements much more than it is being right now?
I would not want to criticize the agencies. Do the best they can with the resources they have. But yes, certainly, if genuine evidence is being leaked to the media or to any other sources, then, I mean, within their ranks, the agency has to determine why exactly that is happening. Because in point of fact, the phone is in their custody at this point in time. But like I said, we don't yet know if those are actually even genuine messages. So.
Absolutely. There's another very interesting point that was part of the case that let's say drugs seized from all the people in the case add up to a commercial quantity. Now, how do you really quantify this in terms of, say, a commercial use or a small amount? What goes into this?
Again, Ashima, I think this is the agency just dragging their powers too far to try and push forward and thread together a case. Now, I don't think I can explain it better than our counsel, Mr. Rohatgi, argued in court, where he said, if I am hypothetically arrested from a hotel room with narcotic substances, it cannot be that if 20 other people unconnected to me are arrested with narcotic substances, you add all of that up and you charge me with a commercial quantity. That is not something, again, it is not something in the letter and spirit of the law. That is something that the agency is saying that is the way they are calculating it, because they're saying it is a conspiracy. That being said, again, the only defense of the conspiracy theory that they put forward in the court was that 8 people were arrested, all with narcotic substances. It cannot just be a coincidence that 8 people on the same cruise had narcotics. Aryan Khan was not connected to a single one of these accused people other than Arbaz Merchant. Even the agency was not able to come up with any link between them. So frankly, in order to prove a conspiracy, like I said earlier, you can't simply say conspiracy because I don't believe it's a coincidence. If they believed that by sheer virtue of being or trying to be on that cruise, you were part of a conspiracy, then, like I said earlier, they should have had 1,300 people in custody.
Absolutely. And even then, NDPS is a very stringent law that we have currently. And on the other hand, there's also this sort of drive to bring down the menace of drugs in the country. It's being put out as a more heinous crime than even culpable homicide. So what are your thoughts just from the point of law? Let's not take into account whether at the other end of this case is a celebrity or not. For common man, what does this act really mean?
So the NDPS Act is a very strong act, and the NCB is given very, very wide powers under the act. That means that the drug menace is a serious thing, and it is a very serious problem that the agencies deal with. And yes, the learned Supreme Court did say that the drug menace is a more serious and heinous problem today than culpable homicide. That being said, what they are referring to is the trade and abuse of narcotic substances as a whole. And they are talking about the drug trade as a whole. 2 teenagers do not represent the full drug menace across India, or 220-somethings. That is with regards to even if you are found with a small amount of personal use consumption, it cannot be said that you are symbolic of the entirety of the drug menace and must be punished as such. That isn't fair, and it's counterproductive. One benefit I feel that the act would have is if it were to show a gradation between first-time offenders, habitual offenders, and there has to be a more serious gradation between the issue of personal quantity, commercial quantities, or small and large quantities. And at the very least, Ashima, and I've always felt this way, even if there are no legislative changes, what will help immensely is just for the act to be implemented in accordance with the letter and spirit of the law. Even if we go forward with the act as it is, people say it's a draconian act, people say it's too harsh an act. It is a wide-ranging act, and it is a very strong act. But even if we go forward with it as is, without any changes, just with appropriate implementation by the agencies, we will be in a far better situation where the process itself is not made into the punishment,
Absolutely, Niharika. Speaking of the process, another question that comes to mind is Aryan Khan was arrested on day 1. Without much of an investigation that went into the matter. Now, how does this really compare with somebody who is not, say, an influential personality? Is that really the norm under the Act? And is bail really not the norm or the rule?
See, let me put it this way. It is not generally in all criminal offences, bail is the rule and jail is the exception. That being said, for NDPS offences and for heinous offences, as was pointed out in the court, the courts have taken exception and have not granted bail in certain instances. Now, the question of celebrity often cuts both ways, because on the one hand, you aren't falling into obscurity. So nobody is going to forget about your case. No, you aren't going to just be one of the other thousands and thousands of under trials languishing in prison without getting any relief and without getting bail. That is not likely to happen to you if you are a well-known person or if you are a celebrity. It also cuts the other way because there's suddenly a lot more scrutiny on you, and you are, I would say, to a certain extent held up to a slightly different standard. Now, one of the arguments put forward when Riya Chakrabarti was being investigated was that celebrities being role models should be put to a higher standard, and their cases should be treated more strictly and with more stringency because they are role models for the youth. I don't agree there. The learned court did not agree either. Everybody has to be equal in the eyes of the law. It cannot be that because you say I am a role model or if I am a well-known person, that you will not grant me the relief that anybody else in my position would have been given. And the learned court disagreed with the agency on that, and they said that everybody had to be treated at par and everybody had to be treated equally. But celebrity is definitely something that can cut both ways.
Absolutely, Niharika. Also, could we look at conspiracy as a concept a little more and understand from you what it really takes to make out a case of conspiracy?
Absolutely. Now, the central tenet of a conspiracy is the theory of meeting of the minds, where that is how the entire thing falls into place, where the agency or the prosecution is able to prove that a group of people came together, there was a meeting of the minds, and for the same purpose, they decided to commit an illegal act. Now, as Mr. Rohatgi very well pointed out in court, ultimately successfully because we got the bail, there was no attempt to even make out a meeting of the minds in this case. There was no linkage between any of the people on the cruise. Aryan Khan and Arbaz Merchant, being friends, were the only linkages they actually sought to make out against Aryan Khan. The agency themselves admitted in court that they did not have any proof of a conspiracy, and they said that conspiracy is hard. It's a hard thing to justify because only the accused persons know why they did what they did, and therefore we leave it to the conscience of the court. I was of the opinion that in order to establish a conspiracy and in order to push forward this theory, especially since they were building this case up, especially with regards to Aryan Khan, as being something much larger and as being involved with dealing or at an international scale, I feel that it was incumbent upon them and it was their responsibility to provide some kind of evidence of a conspiracy if that was the manner in which they wanted to take this case.
Thank you, Niharika. Thank you so much for clearing all those points out for us. And now let's switch gears and talk about your personal journey in law. So much knowledge out there coming from you at a very young age. How does it feel to be a new age lawyer and a woman lawyer in today's time? How's this journey been for you, and what are your thoughts going forward?
It's very, very kind of you to say, Ashima. This is a profession where every day you get the opportunity to learn something new. That's one of the things I love about the law, especially litigation. And I'm very young comparatively, and my knowledge base is very shallow compared to some of my colleagues. And I enjoy the opportunity to just learn from every case that I get and build on that base.
Oh, it's so modest of you to say that, Niharika, but we'd really like to know how's a day in Niharika's shoes? How many hours do you really put into the law, the study of law? I'm sure, legal profession is a profession of constant learning. We all are students forever.
Yes.
So
that it is. The days differ. It all depends on how heavy your days, how many matters you have in court, how many conferences you have set up. If you're lucky, there will be a lot. And if you're lucky, your days will continue to just be as busy as they can be. A good habit that I think every young lawyer inculcates over time is when you have some free time, expand your knowledge base, not just strictly speaking on the law itself, but on a variety of things, because ultimately litigation is the kind of profession where your you have to handle cases on a wide variety of matters. And just having more knowledge, reading deeper, it'll always benefit you, irrespective of where you go.
And where does this discipline really come from? From Mr. Aryan Karanjawala, or have you gotten it from Mrs. Manik Karanjawala?
I am amongst the least disciplined in my family. My sister and my mother are the real workhorses of our family, in fact, and they really put hours and hours towards just not looking up from their files. It's something I learned from both my parents. My love of reading is definitely something I got from both my parents on a wide variety of topics, and I've loved that since I was a kid. So I don't consider that work.
Great, Niharika. So what are the various kinds of practices or areas that really hold your fancy?
So criminal, of course, always held a lot of interest for me. I like white collar crime a great deal. I also like hard crime as well. I like forensics and the medical aspect of it as well. So from a pretty young age, before I went to law school, I always knew that criminal law was a path that I wanted to explore and a profession that I was very interested in. And now, I mean, it's a great profession because you see that more and more young women are getting into criminal law. At one point, it was considered not a very safe profession or not a very safe branch for young women to pursue. But I think that impression is now dissipating, and you see lots of women at every age involved in it, and I've always been fascinated with that section of the law.
Absolutely. And speaking of forensics and medical research, I think that's picking up in India as well. But currently, what would you say is the state of forensics in India?
I'll tell you, Ashima, there are certain aspects of forensics, especially with regards to crime scene investigation, which I think in the next 30 years are going to take a sudden leap forward in India. We already have the know-how about it. We have the know-how, we have a great deal of the technology, and I really feel that if we are able to implement it in the best way possible, it will take our investigation process forward considerably. Because today what you do find is, unfortunately, in some instances, some of the technology, some of the know-how is used. In some instances, it is incorrectly applied. Because in some instances, especially if we can just look at crime scene investigation for a second, very often what happens with crime scenes in India is you have the first responders coming to a crime scene, and those first responders are not necessarily police officials who have dealt with hard crime before. One of the first cases that I had the benefit of being on and helping out on after I graduated from law school was the Arushi Talwar murder case, and we represented her parents. And in that case, in a number of instances, the investigation from day one was compromised because crime scenes were not locked down, crime scenes were not isolated, people were walking around, picking stuff up, putting stuff down. It all leads to tampering with and decontamination of the crime scene. Once your crime scene is contaminated, you are playing for seconds throughout the investigation, and you are playing at a huge disadvantage. And if from the outset we either start a practice, as in the US, of only a detective department will actually go and investigate, and first responders to a scene will merely secure the crime scene and leave it be, or we give basic training to our first responders to ensure that they do not inadvertently or unduly contaminate our crime scenes, it will take our investigative process leaps and bounds into the future, because we have the know-how. Like I said, at the higher levels of our agencies, there are some truly incredible people. They have the know-how, they have the experience. It's just in some cases the way that it is being handled at the ground up with first responders who are not properly equipped to deal with what they find. That is where the whole thing sort of goes askew.
Thank you so much, Niharika. Quite a playbook that we now have, thanks to you, on how things should be. And I really hope that happens, because that will make all the difference to our criminal cases and the prosecution matters. So, away from this, what is your bucket list for 2022? We are in a hybrid model, functioning, the legal fraternities functioning in a hybrid model right now. So what are your thoughts, one, personally, and secondly, on the aspect of the legal landscape? What changes as a new age lawyer would you want in the system as it stands today?
So, personally, and for the sake of the profession as well, of course, I'm hopeful that COVID infection rates in Delhi continue to stay low, so that physical functioning in the courts can safely happen, because the courts are crowded places, and despite every opportunity being taken to social distance, and despite every precaution that's being taken in the courts today, just the sheer volume of people you have in the courts wind up making it an inherently dangerous situation if the infection rates rise. So hopefully they will continue to stay low and we can get back to a more normal form of practice. It was very, very interesting and heartening to see during the lockdown, though, the way the legal profession rose to the challenge and moved into virtual hearings and showed that despite very difficult odds and despite very varied circumstances, the course of justice will continue and the courts will continue to function. The courts will continue to ensure that justice is being done. So that was something very heartening for all of us, especially for the young bar to see, and I think very inspiring for all of us to see. And as a lawyer, personally, I would just continue to hope that I would continue to learn and get the opportunity to work on matters, stay busy, and continue to improve my knowledge base of my profession.
We are very certain you'll continue to do the good work that you're already doing, Niharika. Our best wishes to all of you, and thank you so much for being with us today. And what a wonderful conversation. It was so lovely to know your personal and professional side. So thank you so much.
Thank you so much.
All right. Thank you so much, viewers, for viewing us today. This is BW Legal World Dialogues, and we'll see you another time with another interesting conversation. Thank you so much.